All right, this is going to be a talk on restraining orders. I'm doing it on a little bit of a different format right now, and it's on a webcam through my computer, so it might not take. If it doesn't, then I'll switch back to the old-fashioned method of going on the webcam for my phone. And it looks like it is. Well, supposedly it's working, but I can't be certain. So this is not a page for anybody wishing to obtain a restraining order. If this is what you want, I recommend you contact the local court or police department. All you have to do is go to the courthouse of your jurisdiction, say you're in fear, and the odds of you not getting a restraining order are probably about the same as the odds of the Patriots losing tomorrow night. I would put it at about 1%. It's a page for those who have been, or at least it's a broadcast for those who have been served or threatened with a 209A order. First of all, there are thousands of people in Massachusetts in your position, mostly men, that are accused of varying degrees of abuse, which result in a restraining order being issued against them. These orders are routinely used as leverage in divorce disputes, custody disputes, property disputes. You'll end up losing your weapons if you have weapons. Basically, relationships that have gone sour. I have seen everything from the gamut. And what is devastating to a person who has to deal with this is that you're going to lose your children, at least temporarily. You're going to lose your home, at least temporarily, even if you own the home and it's a girlfriend. You can be expected to be booted out pretty quickly. The ease of getting a restraining order is really what I mentioned in the beginning. It doesn't take a lot for an order to issue. When actuality, the law states that a person would be able to get a restraining order if they can show fear of serious imminent harm. And that's a pretty high standard if you look at the definition in our statute or in our case law. Serious imminent physical harm is extreme harm. It's not a push. It's not, I think I'm in fear. It's not, I want him out of the house tonight. It's significant. However, if you're in front of a judge, the odds are a judge will typically side with the plaintiff on the restraining order. The issues that surface once a restraining order is issued are extreme. Although a restraining order is not a criminal event, violation of that order is. And if there's a vengeful relationship brewing, and probably is at some level, it doesn't take a heck of a lot for a person to get arrested. Let me shut my phone off. I probably should have done that beforehand. But let me just take a look and see if there are any questions that have been posed, since I'm doing this a little bit on the fly with a new format. I just want to take a look and see if it's actually working. So give me a couple of seconds and let me take a look. And it looks like it is, kind of. Let's take a look and if I have any questions. And I do. All right. So far, can you get a restraining order against your father-in-law? You can get a restraining order. A lot depends. Certainly, there's blood relative. But if you're not living together, I think it's going to be really difficult to get a restraining order against your father-in-law. There's another vehicle, and that is called a harassment order, that makes it a little bit easier for someone who's not in a relationship or has a family setting, be it a spouse or a brother, sister, girlfriend or boyfriend. But typically, if a person is living within the home and there's a family type relationship, you might be able to get a restraining order depending on the facts of the case. Can you get a harassment order right away, or do I need to be for international laws to apply? I'm not sure what that actually means. but actually, it was clarified a little bit. Can you get a harassment order right away, or do you need 3 documented incidents? Now, harassment orders is what you just said. You need to have shown 3 separate issues of harassment, and where I see most of these orders, not necessarily in a father-in-law setting, it is next-door neighbors. When there is a next-door neighbor case, the amount of craziness that happens is beyond belief. And trust me, it doesn't take a lot for someone to come up with 3 elements of harassment. So that's typically where you see the harassment order utilized. Most of the time that I've seen it, it's been with next door neighbors, most recently, as well as even if you go back a year or 2. Let me continue on. If, from Johnny, all right, I got a funny feeling what this is going to be. If I was on a cruise, say this week, how far out do I need to be for international laws to apply? As long as you're traveling with a relative who was, let's just say, a retired colonel in the state police, international laws apply immediately in that setting. And I think Mr. Johnny, I'll call him, knows what I'm talking about. But good luck, John, when you're heading out on the cruise. Make sure you bring your father. Even though sometimes I've known him to have alligator hands. Let me continue on. What counts as third-party contact? If people come to collect someone's stuff, can they question people about the incident leading to their restraining order? Well, third-party contact is exactly what it means. If you have a friend and you want to, for whatever reason, have that friend get a message to the plaintiff on the order, that's third-party contact. Where I see a lot of issues recently is through Facebook, Snapchat, Twitter, where friends might be reaching out via that social media platform, and if it can be tied to you, meaning if there's a hidden message in a post, if there's some type of communication that you want to get to someone but afraid to say it yourself, third-party contact is as much a violation of a restraining order as if you picked up the phone and contacted the plaintiff yourself. All right, let's take a look at a question by Penny. Can you get a cease and desist order for a debt collection company? I'm a criminal defense lawyer. I appreciate any questions, but the value of any of my answers regarding a cease and desist law are pretty much essentially worthless. So I'm gonna move on from that. All right, happy Friday, Mike. I appreciate that as well. Let's keep moving on. Let's see. Hold on one sec. All right, so and Julianne asked, by documented incidents, meaning you've called the police on these different settings. Well, it doesn't have to be. Let's say you have a situation where you've noticed a neighbor drive really close and peer into your window, and you take a photograph of that. Let's say you see neighbor walking outside, throwing stones into your yard. You don't need to call the police. It certainly would help in terms of getting a restraining order issued if, in fact, you have those documented with the police. But typically, it is not required. If you just give me 1 second, I'm going to get onto my Facebook Live site on my phone so I can read the questions a little bit easier. Sorry about last week. It was a little bit difficult. I was coming off laryngitis, so let me take a look. Okay. Oh, Alan, how you doing, Alan? All right, let's take a look. If I have any new questions. Is there any worth in having an order removed from your record? And that's a question that was submitted by Josh. Josh, I got to tell you, it's almost impossible to get a restraining order removed from your record unless you can show fraud on the court. Real difficult standard, because a restraining order is not criminal. The Corey law doesn't apply, so it would take a real difficult event, I think, from the lawyer to try to get that removed. The good part about it is a restraining order is not criminal, so it's not going to be on your Corey. The question comes whether or not employers might have the ability to look at that when they do a records check for, let's say, employment. Let me take a look if I have any more questions. I'll give it a couple more minutes. But essentially, if you got a restraining order that's been issued, it's a devastating event. It can really disrupt your life. If there is a pending criminal case, and I would say probably 60 to 70% of all restraining orders have a criminal case that goes along with it, it's really a waste of time to try to fight the order. Once a court sees that there's a criminal case pending, there's absolutely no judge that I'm aware of that would not issue the restraining order unless there was some absolute crazy reason why, given the fact that a person's been charged. But a restraining order is important. Well, it's certainly important to prepare for a restraining order hearing. If you are in a position where you need to fight a restraining order, I always tell clients to try to keep a diary. Certainly, if there are things that are going on and you start thinking that, I don't really trust or have confidence that this relationship won't dissolve and dissolve in a bad way, you might want to keep a journal. You might want to just start taking note of certain unusual behaviors and protect yourself. If you have a restraining order that is in existence against you, you need to be 100% cautious about traveling, especially if you live in the same town. If you work in the same area, it doesn't take a lot for two parties to drive by, especially in small towns. Now, incidental contact can be argued in court, but I must tell you that if there's an allegation that you drove by someone, I think the police are going to err on the side of caution relative to whether or not they make a decision to arrest based upon incidental contact. I think a few more people have chimed in. Let me take a look and see if I can answer a couple of these. All right, looks like we're back to marijuana, Hope. All right, let's check this out. I always like answering marijuana questions. You get pulled over and have marijuana and asked if drugs in the car, I would assume if you're asked if there are drugs in the car, and you have a small amount. How should I answer this since it's legal? Well, I would suggest you always want to be polite to the police. If there's an odor of marijuana, the police are going to come to the car and they're going to start questioning whether or not you're impaired or not. So if there's a small amount of marijuana, you're entitled to travel with a small amount, 1 ounce or below. And if the police officer is questioning you on that, then there must be some reason why they're questioning you. Now, typically, the odor of marijuana in and of itself is not enough to really continue a probe. But just look at it this way. Alcohol is legal. And if you have an odor of alcohol on your breath, even though it's legal, it's going to give the police a little bit more justification to inquire a bit more. And if you become be put in a situation where you're antagonistic to the police officer, it makes the likelihood of your encounter not going as well as you had hoped. Hold on one sec. If I don't see any more questions, then what I'll do is I will sign off, and I will talk to everybody next Friday. Let's see what the next question. How accurate do you think these machines will be? I'm not sure what Stephen's talking about, but I'm assuming he's talking about some of the press that has been in the news lately about marijuana detection and about being able to essentially take what is now a breathalyzer for alcohol and convert that to some type of breathalyzer machine for marijuana. I'm sure it is going to be a long time before that happens, and I would suspect that even if it did happen, it would be a fertile area for a defense lawyer to attack. All right, Hope has my number. All right, thank you. So that's about it. I think I will be back next Friday. And if you have an area of law that you think you might want to have some help with, and you think it might be educational for other people to hear about, send me a message or send me a post on Facebook, and I'll be looking forward to talking to you next week. Bye-bye. Now all I got to do is figure out how to shut this off, now that I have the new setting.